Federalist Society chapter here at the University of Kansas School of Law. We're very excited to have several distinguished guests with us. Congressman Lance Kinzer, for example, congressional candidate Patricia Leitner, our famed alumni Glee Smith is here, and several others. Also, thanks to the press for coming out and covering this event today, and the support of our deans and faculty is invaluable, as I'm sure many of the students can attest to. I'm going to introduce to you a Professor Stephen McAllister, who's a constitutional law and civil rights professor here at KU Law, and he's going to tell you a little bit about Dean Starr in the presentation. And the Federalist Society, for those of you who may not know, is a nonpartisan conservative and libertarian organization that believes in three really simple things. First, that the state exists to protect our freedoms and liberties. Second, that the separation of governmental powers is a very key aspect of our constitutional structure. And third, that it is the province of the judiciary to tell us what the law is, not what the law ought to be. With these three basic principles, as you can imagine, we get into a lot of debates with people, which is our final kind of fourth goal, is just fostering an open discourse about these important issues of our generation and of our nation's governance in general. So once again, thank you all for being here, and please help me welcoming Professor Stephen McAllister.
Thank you, Brandon. I'll keep this short. General Dean Judge Starr has requested that I do that, but I can't keep it probably as short as he might like, because being a teacher here, I understand it's a fact of life for the law students in particular that you keep getting younger every year. And what is often recent history to your professors is ancient or sometimes even prehistory to our students. So with that in mind, I want to just take you very briefly through Dean Starr's legal career to make sure you understand all the remarkable things this remarkable man has done. After graduating from law school, he clerked in the Fifth Circuit. Then he clerked for Chief Justice Warren Burger at the Supreme Court. He then went to one of my favorite law firms, Gibson, Dunn & Crutcher, in the D.C. office, of which I'm also an alum. He then went into the Department of Justice with Attorney General William French Smith. He was appointed to the D.C. Circuit as a judge in 1983, served there for about 6 years until he became the Solicitor General of the United States under the first President Bush, served during that entire term. He then went to Kirkland & Ellis, a very large and prominent Chicago-based law firm, but he was in the D.C. office. He then, in about 1994, took on a little job that many of you are familiar with. He was independent counsel in the Whitewater matter, which turned into being Whitewater, Vincent Foster, Monica Lewinsky, and lots of other things, and that was about a 5-year stint. Since 2004, he has been the Dean of Pepperdine Law School. Remarkably, he continues his work as a litigator and appellate litigator. While Dean, he has appeared in front of the Supreme Court, for example, in the Alaska case a couple years ago involving the student with the Bong Hits for Jesus banner during the Olympic torch procession. He's been involved in California Proposition 8 litigation and several other matters that are ongoing. He's written many articles, given many speeches. He's published a book called First Among Equals, The Supreme Court in American Life. I won't say that I've ever had the pleasure of directly working with Dean Starr, but many of my best and oldest friends have, in fact, worked with him. And to a person, they swear and believe that he is a man of genuine warmth. He's friendly and courteous to all. He's a helpful and constructive person, and he's a man of deep convictions and strong principles. So I hope you'll join me in welcoming the Honorable, the Judge, the General, and now the Dean, Ken Starr.
I am going to hold up two documents. Do you recognize it? And then the Constitution of the United States. So good luck to the Jayhawks when I say that, having gone to the Duke Law School. Please don't boo too loudly because it will be misinterpreted. It's great to be here and to be with someone whom I greatly admire, the Solicitor General of the great state of Kansas, and someone who has served in leadership positions here at this great law school. I've had the privilege of working with your dean, who could not be with us, but who sent her very warm greetings and regrets. She's a great leader among U.S. law school deans. I served under her leadership in a specific effort in August at the American Bar Association annual conclave, and I just assure you that your dean has a very, very outstanding reputation around the country among those of us who are privileged to serve in these positions of stewardship. It's very good to be back in Lawrence, Kansas. Dr. Shamugam, if you're here, I'll just say the last time I was here was at your wonderful son's. And Mrs. Shamugam is here as well. Would the Shamugam stand, please, a distinguished professor of computer science here at the University of Kansas, and his beautiful wife. Of working with one of their very talented kids, one of their talented children, who is now the head of the appellate, and this is just, the years go by, they keep getting younger, the appellate practice at Williams & Connolly, the lawyers in here know, that is a great law firm in Washington, D.C. So thank you for being here, and we love Canon and Dr. Shamugam, another doctor in the family. President Obama had a remarkable trip to Asia, the 8-day trip. And during the course of his visit in China in particular, which of course really arrested the world's attention, and rightly so, President Obama made a number of comments that I think merit our thoughtful reflection this afternoon. This is drawn from a BBC News report. U.S. President Barack Obama has told China that individual rights and freedoms should be available to all. He told an audience of Chinese students that certain freedoms were universal, that they were not limited to Americans. Quoting, this is the BBC piece, our president, "We do not seek to impose any system of government on any other nation, but we also don't believe that the principles we stand for are unique to our nation. Rather," he went on, "these freedoms of expression, freedoms of worship, of access to information, and political participation, we believe, are universal rights." He also said in his statement just 2 days ago with the president of this very important country, quote, "America's bedrock beliefs that all men and women possess certain fundamental human rights are universal rights, and they should thus be available to all people." This, then, it seems to me, is a time, even with the economic distress that touches every person, perhaps on the globe, certainly our country has famously now not been immune from economic distress. And obviously, our president went to China with a very different context, strong China economically, but a China that as yet has not found its way with respect to what our president called universal rights, universal values. So this was not American exceptionalism or particularity, it was a robust vision of a universality of our living together on this planet as human beings. At a time of the American Thanksgiving, just next week, a week from today, one would think it would really be a time of our thoughtful reflection of saying, thank you for the structures and the institutions that we have inherited and under which we live and move and have our daily being. But in fact, not surprisingly, there are very thoughtful voices that are saying we could do so much better. Not with respect to a particular policy, and I'm not here to discuss a particular proposal that may be before a state legislature, before the Congress, the health care debate, and so on. Rather, I'm talking about broader issues and thoughtful voices in the academy that are suggesting that there are fundamental problems with the American constitutional system. Let me draw from two sources. One is a very distinguished professor at the University of Texas Law School, Sanford Sandy Levinson, and the other is former University of Chicago, former Harvard Law School professor, and now at President Obama's right hand, as it were, in OMB, Professor Cass Sunstein. Let me draw from the former. In his book, Our Undemocratic Constitution, Professor Levinson levies a number of charges at the feet of our constitutional structure. He said it should be clear that the Constitution makes the claim that the people rule untenable, inasmuch as majority rule is significantly stymied by the operation of the Constitution itself. His favorite target is not surprising. It's a lot of thoughtful criticism directed at the Electoral College. I now quote from Professor Levinson's thoughtful book. It is the Electoral College that supplies the decisive and overriding reason for rejecting the constitutional status quo and supporting a convention entitled to propose significant revisions to the Constitution. It is an undemocratic and perverse part of the American system of government that ill serves the United States. We're probably all familiar with the criticisms of the Electoral College. He also said, consider how deadlocks in the Electoral College are to be resolved. The answer, according to the Constitution, is that the president be chosen by the House of Representatives, but with a one-state, one-vote basis. Delaware has the same voting power as California or Texas. He also talks about the allocation of voting power in the Senate, reflecting the constitutional structural guarantee that each state will have its 2 senators, no matter, again, how small the state. And thus, the state of Wyoming, not far from here, has 2 United States senators, but 1 member of the House of Representatives. He talks about the presidential veto power hardwired into the Constitution and stymieing what he sees as an overriding moral imperative, which is majority rule. He wrote very powerfully about the president. What if we once again experience a death in the White House and the succession of a person who may be manifestly ill-equipped, whether through lack of adequate experience or widespread popular disdain to take on the monumental burdens and powers of the modern presidency? I'll be very brief with respect to Professor Sunstein, who in his book, The Second Bill of Rights, suggested that because of its advantage of being the oldest constitution, continuing constitution in the world, that America's Constitution is woefully lacking and needs, as it were, a second Bill of Rights. He writes this in his really very, very intriguing book. The American Constitution is the oldest in force in the world. The very oldest constitutions, however, lack social and economic guarantees, which are largely a creation of the 20th century, one might add, really post-World War II and post-Universal Declaration of Human Rights. And then he poses a very interesting question. Why is it that the American Constitution, the existing document, has not been interpreted to include social and economic guarantees? So a perhaps clarion call for the judicial branch, or perhaps it's to the political branches, to interpret in a broader and more generous way the American Constitution and to, as it were, modernize it. I want very briefly, before the question and answer session begins, to draw our attention back to the structure of the Constitution as befits a gathering of the Federalist Society, where we tend to return to first principles as a starting point. If you think, well, that is a deeply conservative value, I will also say that was exactly what Justice Stephen Breyer said in his confirmation hearing. That when we're confronted with an issue, we should return to first principles and make sure that we all at least understand what the first principles are, and then we can go from there. So it seems logical, since we're talking about the Constitution and our constitutional structure, but is it all that it can and should be, to return to the text itself, and in particular, Article 5, Amendment. The Congress. So it begins with Congress. It's a very democratic dimension right here. Not the president, not the judiciary. It's the Article 1 branch. The Congress, whenever, supermajority, 2/3 of both houses shall deem it necessary, but shall deem it necessary seems like it's entrusted to the judgment of the Article 1 branches. Shall propose amendments to this Constitution. Well, what about the states? What if Congress isn't all right? Or on the application of the legislatures, not the governors, not the state Supreme Courts, the legislatures of 2/3 of the several states, so supermajority requirement, shall call a convention, this is what Professor Levinson is calling for proposing amendments, but in either case shall be valid to all intents and purposes as parts of this Constitution when what? Ratified by legislatures of, ratcheted up, 3/4 of the several states, or by conventions in 3/4. So 2/3, 3/4, both supermajority. Nonetheless, a democratic process, but with a supermajority requirement. And perhaps he will be Justice Levinson, but Professor Levinson quarrels with that. And so let's do a very quick review. In the space of 5 minutes, we will cover all 27 constitutional amendments. Yes, there have been 27, and as we all know, we learned this as school children, 10 came almost immediately in 1791. So the convention proposes the Constitution itself on September 17, 1787. The ratification debates occurred in 77, 78, and 88, and then ratification is effected, and the elections are held in late 88 and 89. There was not a single election day. The first Congress, the President, George Washington, we know all that. What does the first Congress do? It responds to the anti-federalist critique. We know all this, and proposes the first 10 amendments, which we call the Bill of Rights. See, we know all this, and this is so wonderful, right? The Bill of Rights. He said, we love our Bill of Rights. Well, I think Professor Sunstein would say, friends, this is from 1791. Get with it. We need a little bit of updating and modernization. So we all know the Bill of Rights. But what did the founding generation do? Were they of the view that other than the Bill of Rights, so that was the great compromise, and candidate James Madison, seeking election to the first Congress, promised the people of Central Virginia, if you elect me, a lot of anti-federalist sentiment in his district, if you elect me, I promise, I pledge to you that I will work assiduously to bring about a Bill of Rights. And he did. He kept his promise, and the rest, of course, is all history. But was that it? Was it in the sense that, well, it's now frozen in time. We've completed the work. It is now, in fact, perfect. Of course not. Because the founding generation knew that there was this horrible evil of slavery, which the convention struggled with. Even George Mason, who, it's almost unspeakable to say it, but who owned more slaves than anyone else at the convention, and the majority were slave owners, said in powerful language that slavery is essentially an incredibly evil enterprise, and it is sapping us of our moral energy and strength. Well, the founding generation went forward, and the 11th Amendment, in response to what? A sense that the states and state power was being compromised. So the 11th Amendment comes in at 1795. In the meantime, what is happening in the Congress of the United States? The Alien and Sedition laws. Where were the courts to protect us? The courts were not there, in fact, to protect us. And then I'll come back to this ever so briefly. Calder versus Bull in 1798, giving a very limited, and it has stood the test of time, for better or for worse, a very limited interpretation to the ex post facto laws. The election of 1800 was, in fact, horrible, with the matter going into Mr. Jefferson pitted against Mr. Adamson. Of course, the election of 1796 was horrible, because who did we elect? Under the flawed provisions of the structure created by the founding generation. And they recognized it. My word. We have as President of the United States Mr. Adams from Massachusetts. But we have as Vice President of the United States Thomas Jefferson. Their worldviews are far apart. As FDR would say, their minds do not go along together. And then the disaster of 1800, called a magnificent catastrophe by my wonderful colleague and Pulitzer Prize winner Ed Larson, that is at the Pepperdine Law School. in his analysis of the election of 1800, you can see why, in light of how horrible that was, in going to the House of Representatives and ballot after ballot because of the perfidy of Aaron Burr. Not his alleged treason later on, but the political perfidy of Aaron Burr. The nation was in turmoil. Who will be our next president? Of course, as we all know, that brought in what Mr. Jefferson called the Revolution of 1800. The founding generation said, we've had enough of that. All right, General Washington was gone, so the president of the convention and the president of the country had died. But most of the founding generation was still very much alive. They said, let's amend the Constitution. And they did. The 12th Amendment. The 12th Amendment said, we're not going to have that anymore. Barack Obama will not, in fact, have Sarah Palin elected as his vice president. That makes sense, doesn't it? In terms of politics, whatever you think about the candidates, that doesn't make sense. Then individual rights. We went into a period of hibernation in terms of amendments to the Constitution until, of course, the perfecting, as it were, of our constitutional order through the shedding of blood in the Civil War and the post-Civil War amendments. Bleeding Kansas, the 13th Amendment, the 14th Amendment, and the 15th Amendment. That cluster within 5 years, 1, 2, 3, because the nation had responded to the evil, the scourge of slavery, to the shedding of blood, to the assassination of Mr. Lincoln, and they responded. But then, years went by, decade after decade, and since that time, that was the final amendment in the 19th century. In the 20th century, we have had Amendments 16 through 27. They fit into 3 categories, really 2. Structure of the federal government / federalism. We would tend to teach that in a single constitutional law course. The rights of the states, the structure of the government. Are we going to have term limits for the President of the United States? Yes, we shall, the 22nd Amendment. What about presidential succession, the 25th Amendment? Well, what about prohibition? Okay, 18th Amendment. That's not working. Okay, that's not working too well, the 21st Amendment. But perhaps most importantly, the great capstone of our constitutional work during the 20th century was the expansion of the franchise, not by traditional interpretation, interestingly enough. Oh, there were decisions along the way, and there were a lot of political actions along the way, especially in the states. But then the nation, we the people, as the preamble of the Constitution puts it, acted through Amendment 5 to the 19th Amendment. It is remarkable that it was only 1920 that women in this country were guaranteed the right to vote. The 23rd Amendment in 1961 extended the right to vote in very important ways to the citizens of the District of Columbia, an issue that continues to this day in terms of the extent of that right. The 24th Amendment, poll tax, responding to the civil rights revolution that the house that Lincoln had built during the Civil War and looking ahead, as he said so eloquently at Gettysburg, still was imperfect. The house, in fact, was still broken and needed a civil rights revolution, including a constitutional amendment, just to make sure that the poll tax was eliminated or any other kind of impediment in terms of property ownership to voting. And then the completion of the democratic process in 1971 in the wake, but still during Vietnam. If someone is old enough to go die for his or her country, shouldn't that person be able to vote? The 26th Amendment. During the course of our history, a number of proposed amendments have been offered on the floor of the Congress and the House of Representatives. During the 1780s, a political scientist doing the count said there were 196 proposed amendments. Gee, that strikes me as odd because the Constitution only came in 1789, but that was his count. In the 1790s, however, a more stable time, 42, 1 came in, actually 2 came in. In the decade of the 18th, I could keep going, but let me march forward, but you see they're sort of double digit, maybe a slow digit. But as you scroll down decade after decade, the 1960s, suddenly the explosion of proposed constitutional amendments. During the 1960s, according to this count, 2,598 constitutional amendment proposals were laid before the House or the Senate. That has subsided. In the 1970s, a time of ferment, 2019. Since that time, we're back down to 3 digits. So what do we glean from this? It lends itself, I think, to, and I'll be interested in the conversation, but at least perhaps the confirmation of Professor Levinson's critique that it's very hard, and a political scientist from whose work he draws on, and that maybe this very same work just said it's virtually impossible to, in fact, get an amendment to the Constitution. But it is, of course, it has to be qualified. Virtually, because think of the structure, the response over our 2 centuries of history, the Bill of Rights, the post-Civil War amendments, the tinkering with the federalism structure, the structure of government, presidential selection, presidential terms, and then the expansion of the franchise through constitutional amendment. Isn't that interesting? So let me close by going back to Calvin versus Bull, 1798. One of the things that was going on at the time of the Revolution and during the colonial experience, but even after the Revolution under the Articles of Confederation, is that state legislatures were taking a very active role in doing what? In reopening judgments of courts. And so in Connecticut, there was a family feud, not in the violent sense, but over a will. The Calder family against the Bull family. And it goes to court, and a final judgment is issued, and the Bull family wins. I may have that reversed. The Calders don't like it. Let's just say the Smiths and the Jones. But you get the idea. The losers go to the legislature and said, we lost in Connecticut probate court. We want you to reopen the case. There was no suggestion of fraud or corruption. But the legislature said, we will do that. And so the case was reopened, and the losers from round 1, final judgment, became the winners in round 2. The losers, the Calders, the eventual losers who had won, take it all the way to the Supreme Court of the United States, and the argument is this is ex post facto. The legislature is in fact legislating in this particular way that is upset. You get the idea. We were at rest, the will had been probated, and the judgment had in fact issued. At that time, the Supreme Court of the United States, this is 1798, had a membership of 6, not the 9 that we're accustomed to. The number expanded as the country expanded, and the duties with respect to regional circuits expanded, or what we would now call regional circuits, now 9. FDR famously wanted to push that number up, right? And the people recoiled at the idea of expanding the number of justices. But that can be done not through a constitutional amendment, but simply by a law passed by Congress and presented to the President of the United States. But only 4 justices spoke. They were unanimous that there was no ex post facto quality to this particular action of the Connecticut legislature. The 2 justices who were absent were the Connecticut native, Connecticut Yankee, Oliver Ellsworth, who was Chief Justice of the United States. He hadn't recused himself. He had just missed the argument because he had been ill. He was in poor health. James Wilson, who had been at Philadelphia, who was one of the most influential people on the floor at Philadelphia, one of the most distinguished lawyers in the United States in his time, was, you can appreciate this, Professor, hiding from his creditors. He could go deeply into that. We don't like to think of lawyers being deeply in debt. But as a sitting justice, he was literally hiding from his creditors because in those days, what happened to debtors? Prison. Did you hear that? The P word, prison. So, let us give thanks. We have all manner of reason to give thanks. But anyway, so James Wilson was in hiding. So he wasn't hearing the case either. So 4 justices heard it, and then there was a great conversation that you read at some point in your law school career. And I'll just therefore incorporate by reference whatever course brought you, Calder versus Bull. The conversation, I'm calling it that, it's a written conversation between Justice Samuel Chase, yes, he who was impeached at the instance of Thomas Jefferson. Once Jefferson came to power, he wanted to go after the Federalist judges. Mr. Jefferson was a pretty tough guy. So Samuel Chase, on the one hand, and James Iredell from North Carolina, both were Federalists. Everybody on the court was a Federalist at that time. So each had a very robust view of the national power. They were sort of looking ahead, as it were, to John Marshall's Supreme Court. The court, not only at Marbury, but at Gibbons versus Ogden and McCulloch versus Maryland, those nationalizing. What about the power? That's the power of the nation through the political process. What about the power of the courts? Justice Chase, while holding, as you now know, that no, the ex post facto clause does not reach civil matters, it's only a prohibition with respect to criminal punishments. But if the legislature passes a law that is contrary to notions of natural justice, those kind of universal rights that our president is so eloquently articulating in China, then the judges should strike it down as against the social compact. James Iredell, destined to die the following year, a great friend of the Constitution and one of the most powerful voices in North Carolina to secure ratification with North Carolina was holding out. You see, the first Congress was elected without North Carolina. The President of the United States, George Washington, took the oath of office without North Carolina. Also without Rhode Island. It was part of the olive branch of diplomacy with the founding generation. Let us respond quickly to the concerns about the lack of protection of human liberty by fashioning a Bill of Rights. And Iredell used that to very good effect as the leading proponent of ratification. And General Washington rewarded him by appointing him to the Supreme Court of the United States. The words of James Iredell: "The authority to declare a law void is of a delicate and awful nature, and the court will never resort to that authority but in a clear and urgent case. If the legislature of the Union or a legislature of any member of the Union shall pass a law within the general scope of the constitutional power, the court cannot pronounce it to be void because it is in their judgment contrary to principles of natural justice. The ideas of natural justice are regulated by no fixed standards. The ablest and purest men, we would be gender neutral, have differed upon the subject, and all that this court could properly say in such an event would be that the legislature, possessed of an equal right of an opinion, had passed an act which, in the opinion of the judges, was inconsistent with abstract principles of natural right and natural justice." This is the conversation between Justice Chase and Justice Iredell that continues to this day and is destined to continue throughout the life of our constitutional republic. Let freedom ring. God bless America. Let us give thanks for our tradition at Thanksgiving, and I look forward to your questions.
If anybody has any questions, I'm going to kind of moderate that. I'm sure Dean Judge General Starr would appreciate answering them. So it's one of the hardest things to do with the distinguished visitor is figuring out what to call him by first. So if anybody has any questions, feel free to ask.
Is a non-citizen of the United States that's tried in a federal criminal court entitled to Fifth Amendment protection?
Is a non-citizen? Yes. Tried in a United States court? Yes. Do you have reason to believe that a non-U.S. citizen tried in a U.S. court would not?
A terrorist, for example.
An alleged terrorist?
Alleged terrorist. Well, Attorney General Holder said that he was going to be convicted, so that's why I used the word terrorist.
Well, that's a prosecutor's predictive judgment.
Alleged terrorist, sorry.
No, in the courts of the United States, the full panoply of rights sets in. I know of no exception. I might want to think about that and be corrected if someone says, oh no, but what about the following provision? But in terms of a basic constitutional right, the Fifth Amendment protection and so forth will in fact, I believe, apply. Why don't you, Steve, you can see people.
Do you admire the Constitution's brevity? And if so, what do you think is the value of its brevity? For example, do you accept the idea that, well, it omits certain things because if it included certain guarantees and specific rights, it would by omission imply that the lack of a guarantee of what it omits?
Let me ask the first part. Answer the first part and then go to the very interesting second part, which is an interpretive question, but you first asked for the opinion. It will probably not surprise you to know that I'm a great admirer of America's Constitution, and that it in fact was intended to be a charter of limited government. One of the things that you heard lifted up here. And why is that? Compare structurally the text of Article 1, the legislative power, to Article 2 and Article 3. In fact, why don't we turn to it instead of my doing it from memory? I have two copies of the Constitution. One is my sentimental copy that doesn't have the 27th Amendment. I have nothing against the 27th Amendment. Let's go to Article 2, because then the language of Article 1, Section 1 will stand out in sharp contrast. I hope you all do this in common law. You do this, don't you? You take the text and you're working the text. Oh, you mean you're just working through cases, interpreting? Didn't mean that to be churlish and nasty. But we should go to the text. The courts go to the text, so perhaps we as lawyers and law students should go to the text. Article 2, Section 1. The executive power shall be vested in a president of the United States of America. Article 3. The judicial power of the United States shall be vested in one Supreme Court. So we see the architecture, the similarities. These are good lawyers, the Committee on Detail, the Committee on Style. So one would then assume all legislative powers herein granted. Big shift, structurally, shall be vested in a Congress of the United States, which, and then, here was the key move. We're going to divide the legislative power. We're not going to have a unified legislature. To the contrary, we're going to have a disunified legislative power bicameralism. And we're going to give the president this important role in lawmaking. So the president, we just call it checks and balances. We don't think about it, but if we stop and think about it, yes. You can't exclude the President of the United States from the law-making process. You can override his veto, but that's going to take a lot. The President is an actor on that stage. But let's come back to Congress. All legislative powers herein granted. And then compare structurally Article 1 to Article 2 and Article 3. Article 2 is fairly short. Article 3 is very short. In fact, Article 3, Section 3 is talking about treason. That was a big issue then. It's not such a big issue now, but of course they were accustomed to, we will either hang separately or we'll all hang together. They were revolutionaries. They knew what they were facing. John Hancock, all that. They knew it was curtains. It was all over if they didn't succeed. So what were they worried about treason? Okay, so they've got to put it somewhere. They put it in Article 3. Article 1 says here are the powers that Congress has. Now, a whole lot of powers, including a uniform law of bankruptcy. Isn't that interesting? The word uniform very rarely appears in the Constitution. It appears with respect to naturalization. Those who come here, it's very good. And Congress has uniform rule of naturalization. By the way, Akhil Amar of the Yale Law School taught us to be much more deeply textualist. Akhil Amar of the Yale Law School taught us, or reminded us, I should say, to be much more deeply textualist, because when you're deeply textualist, the text, like a sacred text, yields up. I don't need to read the sacred scriptures anymore of my faith community. I read them once. Well, if you read them again, you might learn something anew, a fresh insight, or a new approach, and so forth. And so, too, Akil says, recently promoted to Serling Professor of Law at Yale University. He's no longer just self-made Professor of Law at the law school. Please, please, we students, reflect on the text. This is telling us something. And what is it? It's limited government. I happen to embrace that because look what has happened. Once we perfected the Constitution through the shedding of blood and the post-Civil War amendments in the House that Lincoln built and then was truly perfected through the Civil Rights Movement, and those that invited to the democratic conversation through constitutional amendments under Article 5. Why am I not a huge proponent of modern constitutions? I think it's a terrific. In fact, I had a conversation by email with a very thoughtful group of people who are working on a constitution for Burma, if Burma can become free. And I have no objection whatsoever to all those myriad rights articulated brilliantly in the Universal Declaration of Human Rights being incorporated in a modern constitution. I also embrace, I was in Uganda this summer, and I was meeting with the father of the modern Ugandan constitution, the post-Idi Amin constitution, and building in separation of powers and so forth. I said, this is magnificent. They spent 2 years holding town hall meetings. Our constitutional convention was behind closed doors, and General Washington remonstrated with one who had loose lips and a tablet. But we came out all right, as long as we have a Article 5, because we can amend, and that's the conversation that it seems to me can continue.
What would your response be to the argument that the language containing the words the federal government will provide for the general welfare? I think it's Section 8, or Article 1, Section 8.
It's actually in the preamble.
Okay. What would you make of
To
the
promote
argument?
the general welfare and secure the blessings of liberty to ourselves and our posterity.
What would your response be to someone who said that justified the constitutionality of universal health care system?
Well, first of all, the preamble is not a specific grant of power. I would turn to Article 1, Section 8, so I'm a textualist, structuralist, and I would want to scroll through here. Oops, I see regulation of commerce. Okay, and there's been a lot of law with respect to the regulation of commerce. And then, of course, I would scroll all the way down to the final clause, the necessary and proper clause, and a very interesting issue there. So my own view is that Congress has extremely broad powers. Now, can it operate on a particular person? It's a very interesting issue. You will go buy health insurance? I think that's kind of a neat question. Right?
Speaking as someone who's taken a very unique career path from being an advocate to a member of the judiciary, back to being an advocate, can you speak to how your experience on the judiciary has affected your style or approach as an advocate?
I believe it's helpful and important for all advocates to try as best he, she, they can to understand the judicial role. What is it that the judge, the conscientious, reasonable judge, is thinking about? What's my job today? And to be as responsive to that as possible. I think part of that is to recognize, therefore, that if the case has gone to argument before a court of appeals, or certainly in the Supreme Court of the United States, there really is something to be said for the other side. And one lesson that I saw, and I tried to take it to heart early on in my very brief career as a judge, was an advocate arguing one who had been a judge. And the presiding judge of our three-judge panel says, but counsel, and then he pointed to a potential vulnerability in the case, in that side's position. And I always remember counsel's response. I've never been able to say it nearly so artfully, but it was something like this. Your Honor, you've identified the strongest part of my brother's submission. But you should not accept it for the following reason, or it should not change the result for the following, then you've got your three reasons. So instead of trying to avoid it, ignore the elephant in the room, come as promptly as possible to grips with it. Another lesson, the final lesson is, what is in fact, as Paul Gewirtz of the Yale Law School, I didn't know what he meant when I first heard of this, could you repeat that? What is the emotive core of the case? Or as Floyd Abrams, the great First Amendment advocate, would say, can I explain this to my 11-year-old, he's now grandpa, but this was a long time ago, can I explain this to my 11-year-old around the dinner table? That's a pretty good test for an advocate, that I can explain what I'm trying to accomplish and persuade this court to hopefully an intelligent, listening 11-year-old. Floyd Abrams has really smart kids. In fact, that 11-year-old is Dan Abrams. Ever heard of Dan Abrams? So, Dan didn't go into law, did he? I guess he got tired of those dinner table conversations, but he's had a great career in journalism. But can I explain it? So what is the emotive core of the case? What is the central point of the case? But again, recognize the vulnerabilities and come to grips with them.
I'm going to ask one of the last questions. I was just wondering if you could pontificate a little bit about your work that you've done in Uganda and Burma, and just kind of what that looks like and what your overall goals, I think, are for those developments.
Well, I would say, and thank you, Brandon, for asking that our law students, and I hope all law students, have a real heart for being justice seekers right here at home. That means, obviously, the most familiar thing, you hear this from the first day of orientation, that a lawyer has a moral responsibility to the community to take on pro bono work. So I have done death penalty work. And so I'm asked, well, why would you do death penalty work? Are you an abolitionist? I'm not an abolitionist. I'm troubled by the administration of the death penalty in most states. I'm not troubled by it in terms of the way the Congress of the United States is, I think, very thoughtfully. But I'm troubled by a lot of what I see by the administration of the death penalty. But whatever my views as a citizen, if we're going to have the death penalty, then lawyers need to become involved if they possibly can, if they have the skill set. But we also need, and this happens to also just reflect the worldview of what Scripture enjoins us to worry about the least of these, those who are really hurting, both here at home. So we have an urban initiative that I inherited, but one of the things that I wanted to do was to build on what I saw, including through your debate partner, Liz Alvarez, the kind of back when he was in college at ACU in the great state of Texas. What Liz and others brought to Pepperdine was something that I said, I want to encourage this. I want to encourage this. So to build an absolute powerful engine of serving in very small number of ways the cause of global justice. So we connected with Muhammad Yunus, winner of the Pulitzer Prize, of the Nobel Peace Prize in 2006, for his work with the poor and microfinance. I think he is credited, perhaps rightly so, as being the first popularizer of the idea. And of course, he's a PhD in economics and may have, in fact, done the conceptual work. But whether he did or didn't, he showed by his work as an academic, and then he went into his native Bangladeshi communities and started doing things and finding ways of relieving oppression. And so much can be done by a person, two persons, and so forth. And so, in March, a number of now alums from the Pepperdine Law School are going to go to Uganda with the approbation of the courts, including Chief Justice Ben Odoki, who is the father of the Constitution, who worries about the administration of justice because you see there are people languishing in Ugandan prisons. And I'm not picking on Uganda, it's just we have a very close relationship and a memorandum of understanding with Uganda, who these individuals may be in prison for 2 or 3 years and they've never seen a judicial officer. And they may be innocent of their crimes. So let us give thanks for our speedy trial rights as Americans, both constitutional and statutory. These are precious liberties, but we need to, in fact, create a cadre and a ever-growing cadre of justice seekers around the world. They may be destined to become great lawyers in Kansas City or St. Louis or in New York or in Los Angeles or whatever. But hopefully, all persons in law school will have a real heart for, guess what? Let me close with thanks to you for your patience, with the words of the preamble of the Constitution. Because the preamble tells us what it's really all about. We, the people of the United States, in order to form a more perfect union, under the Articles of Confederation. And then what is, okay, so that's a very high goal, to form a more perfect union. And then what is the first stated goal? Establish justice. That's even before providing for the common defense. Because if you do not have a just society filled with justice seekers, you have nothing to defend. Thank you.